Before you buy your next home, there's one decision that could save your family months of unnecessary legal complications in the future. Should you buy in your trust or in your personal name? In the next few minutes, I'll explain the advantages of each approach. When buying in a trust makes sense, and the most common mistake I see homeowners make. Let's talk about it. I'm Paula Aragone, CEO and President of Aragone & Associates here in Orange County. For more than 23 years, I've helped hundreds of families buy, sell, invest in, and transition real estate through every stage of life. From first-time home buyers, luxury properties, to trust and inherited estates, all while maximizing value and minimizing stress. This channel is designed to answer the questions you're actually asking so you can make informed decisions, avoid costly mistakes, and protect one of your most important investments. If you already have a living trust, the best practice is generally to purchase your home directly in the name of your trust from the very beginning. Can you buy the property in your personal name first and transfer it into your trust later? Absolutely. But should you? Usually not. Here's why. I've seen many people purchase a home with every intention of transferring it into the trust after closing. Then life happens. Between moving, work, family vacations, and everything else, weeks turn into months, months into years, and before they know it, the property is still titled in their individual names. If your trust is already established before you open escrow, your realtor, escrow officer, title company, and estate planning attorney can all work together to ensure the property is vested correctly from day one. At Aragone & Associates, this is one of the conversations we have before escrow even opens because we believe that protecting your investment starts long before closing date. It is simply part of our commitment to helping clients maximize value while minimizing stress. So, why does this matter? Because if a property isn't properly transferred into your trust, it could be subject to probate depending on your individual circumstances. In California, probate fees are generally calculated based on the gross value of the property, not the equity, and the process can take months and in many cases more than a year, depending on complexities of the estate. I've met families who believe everything had been handled correctly, only to discover after losing a loved one that they had forgotten the property was never transferred into the trust. That single oversight turned what could have been a straightforward transition into months of court proceedings during an already difficult time. The good news is that with a little planning up front, situations like these are often preventable. If you already have a trust, let your realtor know before you begin the home buying process. So, the realtor, escrow officer, title company, and estate planning attorney can coordinate everything correctly from the start. If you don't have a trust yet, purchasing a home is often an ideal time to speak with an estate planning attorney about whether establishing one makes sense for your situation. And if you don't already have an estate planning attorney, we'd be happy to introduce you to experienced professionals we know and trust. If you're buying a home, or you already own property and you're not sure how title is currently held, download my free trust checklist using the link below. It's designed to help you make sure that one of the largest investments that you're going to make is protected before and after your escrow closes. And if you have a trust or real estate question you'd like me to answer in a future episode, leave it in the comments below or reach out to us. I read every question and yours may be featured in an upcoming episode. I'm Paula Aragone with Aragone & Associates, helping families maximize value, minimize stress, and make informed real estate decisions through every stage of life. Thank you for watching, and I'll see you next time.